Now, if you're a homeowner and you're saying, hey, something's wrong here, we keep burning money, the numbers don't add up, at that point, there's smoke, right? And you suspect it. Now, there's certain things you can do in California. You could always request, it's under the Civil Code 5200, which is a document request, which is demanding the association turn over all of the financial documents so you can review those. I mean, that would be a good place to start. But let's say you find something where you have a good faith reason to believe that there's some self-dealing, or embezzlement, or however you want to frame it. Legally, at that point, really what you're doing is you're putting the association on notice of it. To an extent, you're going to have to call the person out. So that's, I guess, a life decision. Do you want to call this person out and live with that? And if you're wrong, well, you just called someone out. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of L.S. Carlson Law. Welcome back to our show. And today's episode really puts an end to the topic of bad actors in an association, or a bad association, or a bad HOA. So far, we've gone over the tyrant, the incompetent, and the meddler. And today we're really focusing on the self-dealer, which is its own genre of, in my mind, a horrible director or board member. I today also have Jenny on the show. She's back. Welcome.
Thanks for having me.
Thanks for being here. And I have Marty.
Hello.
Hi, Marty. Okay, so the self-dealer. How would you guys like to start this one?
Let's go over the common traits. Actually, give them a quick overview of the self-dealer, and then we'll go into all of the personality traits.
Yeah, self-dealer is complicated because really they're the perfect sort of, I would say, director in the sense that on the surface, they look really good. You know, the tyrant is very obvious, right? They have these overt personalities where they're seizing power. They don't listen to people. The meddler, because they're up in everyone's business.
Why is that my favorite? This is always going to be my favorite.
And the incompetent just displays their incompetency left and right. So it's apparent. The problem with the self-dealer, though, they may be sort of surface-wise perfect. You say, oh my, this is a wonderful director. They do everything that they're supposed to do. It's really under the surface where the problem is. And so when we talk about self-dealer, what they're really doing is they're utilizing their position at the board to sort of benefit themselves. So that could be, it's typically financial. So that's where you have some form of embezzlement, right? Mm-hmm. They have access to the financials, and under everyone's noses, they're taking money from the community.
And it doesn't have to be direct. It could be indirect as well.
Yeah, so there's different forms. There's some setups where they'll actually set up another company, a vendor, a landscaping company, or their uncle owns a landscaping company. And their position as a board member, they'll contract with that company, and they'll get kickbacks from it, right? Yeah. That's a form of self-dealing, which is in violation of, obviously, the Davis-Sterling Act in California. It breaches their fiduciary obligations to the community. But again, you don't always see it on the surface. So that's what we're talking about when we're talking about the self-dealer.
Perfect. Let's get into some of the definitions.
Yeah, we got some good ones. Okay, yeah, I like these. So again, going back to financial gain, that really is the driver here because the self-dealer is trying to monetize the relationship with the board individually. They're trying to make money in their position, which is completely opposite, and it's the antithesis of what they're supposed to be doing. You're supposed to be on the board. You're supposed to be benefiting the community as a whole.
Correct.
There's really no self-interest which should come into play. But a self-dealer will sit at the table and not say to themselves, hey, how do we make this community better? How do we improve the community? What they say to themselves is, hey, how can I get a cut of what's happening?
How can I profit from this somehow?
Correct.
Now, it could be something a little less egregious. Like we're going to buy a power washer so we can power wash the pool area, but they decide to keep it at their house and use it to power wash their car every other week.
Yeah, I guess you have these micro events.
Yeah.
Micro self-dealing.
Yeah.
Right? Where they say, here's another one. And I like your example. I think, when they're utilizing community property to their benefit. So I guess it doesn't always have to be financial in a strictly financial economic sense.
Yeah.
But they could leverage other assets that are owned by the community, but they use them for themselves. Another version of that is landscaping company comes in and the self-dealer goes to that landscaping company and says, hey, I want you to do my personal property.
Oh, sure.
There's an improvement there. Or the handyman who works for the community, they say, hey, can you fix my light bulbs or, patch some drywall?
Just come by real quick.
Correct.
Now, does that violate the Davis-Sterling Act as well? Some of these little micro dealings, or is there a gray area that you have to kind of?
No, I think in general, when you're looking at their fiduciary responsibilities, anytime you sort of step in and you take and you pull away assets of the community and use it to your own self-benefit, there's a breach of fiduciary. You are violating your role as a director. Now, in terms of economically, what are the damages?
Exactly.
Now you're more into it's de minimis, right?
Yeah.
So if anything, you're not always looking to disgorge or say, hey, you used the power washer 17 times and each time you used it was $8 a pop. We want $100 back.
Right.
You're really looking at it as like, hey, you violated your obligations as a director. We want you off the board.
Sure.
Yeah.
That's really I think the goal with those micro infractions.
Understood.
Well, interestingly enough, I spoke with somebody at my son's football practice who was on their HOA board, and she mentioned something about pool cleaning supplies that I guess the organic version of chlorine is really in right now. And if you store that in a public or an access point where everybody can reach it, people will tend to often use or take the pool cleaning
What a
supplies.
surprise.
Well,
So little things like that.
That's interesting because, in that scenario, what you're having owners pulling out assets from the community.
Right.
Well, one was a board member.
Well, there you go. So, okay. Doesn't surprise me. So,
And other homeowners.
And other homeowners. There you go.
yeah. So, yeah, it's like a feeding frenzy. The other one you identify as conflict of interest, this sort of explains itself, but you're right, it's a conflict. When you're there to promote the community, to better the association, and you're looking out for your own self-interests, the conflict arises immediately. So
Sure.
conflict of interest, that's a common theme in these.
And that would go back to your uncle owns the landscaping business and they're not contracting with anybody else. They're not getting fair bids and you're not disclosing it and you move on.
Yeah, you're driving this one vendor
Right.
because you are going to monetize, even though there's 7 other vendors who are better.
Sure.
What if it's not even you're going to monetize, but just it's almost like a family favor? Like you're
Right.
actually just trying to benefit your uncle.
Well, there's also it's derived from self-interest in some way.
Okay.
Now that's a little bit more intangible. Now, really, what a board is supposed to do is they're supposed to say, hey, there's 5 vendors. Let's look at them equally. Which one is going to best serve the community? That's the question. Not, hey, I should pick this person because it's a family thing and I'm going to be awesome with my family. My family will love me. That shouldn't factor into the decision.
Well, that goes into the next one a little bit with lack of transparency. I would assume that if you're being above board and getting several bids and you disclose, just so you know, this is an uncle of mine, I'm going to recuse myself of making a selection here based on X, Y, and Z.
Yeah, so the lack of transparency, could be very egregious. It could be actually concealment. So there you might have someone who is actually taking money, embezzling from the community, but they're cooking the books.
Oh.
They're hiding their tracks. Now, what's interesting with embezzlement nowadays is everything's electronic. So it's a little bit harder if you do a deep dive into the financials and you see these wires going out to, some third party, and the third party ends up, being an LLC owned by that director.
Yeah.
So there could be concealment, though, on the documents generated sort of explaining the transfers, but without actually seeing the transfers. That's a tremendous form of concealment, misrepresentation, which, again, goes to lack of transparency.
Sure.
Lesser forms might be, hey, here are 5 vendors. I really like vendor 3. And they don't tell you that, their cousin Vinny owns,
Cousin Vinny, I love it.
vendor 3, right?
Sure.
Yeah.
So that's the lack of transparency. But yeah, that's a common thread in these. And Marty, I love your notes. It keeps us so
He's
organized.
so on top of this.
I do my best here.
So lack of transparency also goes to non-disclosure.
Sure.
Non-disclosure is essentially the same thing. They're not disclosing material information, which is important, that may bias their decision. So
My cousin Vinny.
yep.
Yeah.
We don't sell them.
So the unfair advantages, yeah. So when you're in a director chair, you do have power. You have a power to make decisions. You have a power to influence. And if you're taking that position, influencing the board, influencing decision making, which benefits yourself, and that's your primary motive, that's problematic. So that is what I think we're getting at when we say unfair advantage in the position, right?
Yeah.
Sure.
And again, you have abuse of power that is essentially an absolute abuse of power. They're abusing their position, right, which is a position of power. When you're in a director role, you do have power. And the power that you have is supposed to, again, go to the betterment of the community.
The greater good, not self-serving.
Correct. And so that becomes its own abuse of power.
I have a side question.
Hit me.
Are there term limits defined in HOAs?
Typically, yeah, if you go into the CC&Rs or bylaws, there's every association has its own sort of setup. But yeah, you'd go to the CC&Rs, the governing documents first to determine term limits, et cetera. So excessive compensation, that's another form of self-dealing in the sense that somehow they're being compensated wrongfully. It's excessive. And normally directors, board members, they're not compensated. It's a voluntary position, right? They're not getting paid to be on the board. It's voluntary, right?
I have seen in some situations, though, if they take a particular role, at least on Reddit, so grain of salt, that some board members are paid to perform certain functions like bookkeeping or something in particular.
To the extent that it falls under your normal purview, if they step in as an extraordinary resource for the association. Now, I've seen it before where it's a very small association, a board member is on the board, but on the other side of it, they help manage the community. They serve essentially as a management company, but there is compensation for that. Because normally how an association works is you have a board come together, they're volunteers, they make decisions, right? They say, hey, I think we need to do this. I think we need to up the dues. I think we need to levy fines. But the arm that executes upon that is a management company that is typically a third party hired by the association.
Gotcha.
Because ultimately, you get on the board, you don't want to be sitting there at your home mailing out checks.
Sure.
Right? You agree to think about these things, make decisions, do board meetings, serve in that function and as that role. But a lot of the mechanical stuff, you just don't have time for.
Right.
Sure.
And, sort of association law assumes that. So that's where you have the whole industry set up to help service a board. That's a management company. Now, what's interesting there is frequently a lot of the disputes that we see, it's the management company that's causing a lot of problems, right? The homeowner will come to us and say, hey, the management company isn't responding, or the management company keeps finding me even though whatever infraction has been addressed, or the management company is supposed to repair a common area roof. They failed to do so. So a lot of venom is spit towards a management company, rightfully so, because they're dropping the ball.
Right.
But the assumption sort of baked in is that the homeowner has a cause of action or some sort of recourse against the management company. Legally, that's an incorrect way of looking at it, because what you have to understand is the association has hired the vendor, which is the management company. And if the management company is failing or is acting negligently or is just, dropping the ball, that misconduct is imputed back to the association.
Okay.
Sure.
So it's under an agency theory of law. So look at the management company as simply an agent for the association.
Well said.
Thank you. Not my first rodeo with that concept. All right. So that's excessive compensation. Resistance to accountability. I think what you're getting to there is, if someone calls them out and says, hey, you're siphoning off money, yeah, there's probably a resistance to that statement. They may try to spin it out. They may try to say something differently. But once you catch a self-dealer, they really have very little to argue.
But there's a lot of these are entangled, because I can see the resistance to accountability goes to lack of transparency and whatnot. So a lot of these, you're usually ticking a couple of these boxes when you talk
100%.
about the self-dealer.
Yeah, and I think resistance to accountability is maybe better said. It's sort of a cloak and dagger play. They do not want to be visible. So yeah, they're not taking accountability for their embezzlement because they don't want to get caught.
Yeah.
So, when I hear about accountability to me is like, hey, we screwed up. We need to address this. But this is sort of an active, mindful, conscious wrong that happens over and over and over again. As opposed to, hey, we were supposed to fix a roof. We screwed up. We didn't know about it.
Yeah.
That's, the board is holding themselves accountable when they identify that. That's a form of negligence, and they say, hey, we fell below the standard of care. What happens with the self-dealer, this is intentional. There's an intent to steal, which is, I don't think.
Malicious in nature, yeah.
Correct.
So the question is, kind of moving on to the next area, if you suspect someone is self-dealing, I would assume it's pretty low-key in most situations there, but you start suspecting it, and you don't want to call somebody out so that you live next door to, right? So how do you broach the subject? Like, how do you start raising the red flags and trying to get them out of the board and move
or their
on?
role?
Yeah.
Yeah.
Their role.
So with self-dealing and embezzlement, it gets complicated quick. And I'll try to break it down in very simplistic form. So if you're an association is a legal entity. And when you have a legal entity and someone is self-dealing, the actual standing to go after that person is the entity. So the entity needs to go after that individual. Now, if you're a homeowner and you're saying, hey, something's wrong here, we keep burning money, the numbers don't add up, at that point there's smoke. Right? And you suspect it. Now, there's certain things you can do in California. You could always request, it's under the Civil Code 5200, which is a document request, which is demanding the association turn over all of the financial documents so you can review those. That would be a good place to start. But let's say you find something where you have a good faith reason to believe that there's some self-dealing.
Yeah.
Or embezzlement, or however you want to frame it. Legally, at that point, really what you're doing is you're putting the association on notice of it. To an extent, you're going to have to call the person out. So that's, I guess, a life decision. Do you want to call this person out and live with that? And if you're wrong, well, you just called someone out, even if you had a good faith belief that this was happening. So I suppose first you have to make that decision. Do you want to pursue this? And then at that point, once you put the association on notice, and the association is looking at it, and there's some teeth or credibility to what you're saying, you're able to provide something that actually lays a foundation for this potential. It's incumbent then upon the association to investigate. And often how we see it play out is the association will hire a legal team to investigate. And then the legal team will bring that. Bless you. You okay? You want some water? We'll take a quick time out.
We'll do another
Swipe.
another swipe.
What?
Other than you have COVID now.
You have the COVID?
Just ignore my COVID.
I gotta make sure I'm
Yeah, I'm tuck that in.
trying to. Embarrassing.
Okay, when did I start talking?
Embarrassing.
Coughing.
All right.
Okay,
All right. So at that point, the association will often hire a law firm to investigate the alleged embezzlement or self-dealing. And at the end of that, the law firm will come and bring its findings to the association. Now, what's interesting is the association technically has a business decision to make there, and they have to determine whether or not it's worth prosecuting and seeking disgorgement. Because
Is that a criminal charge at that point?
Well, possibly, yeah. Now,
Interesting.
will the attorney general or will someone actually prosecute?
Yeah.
Maybe not, because now you're looking at resources, government resources, and if the district attorney is dealing with a lot of crime,
Yeah.
and you say, "Hey, this person is stealing chlorine," they may say, "Get
it's
in line."
organic.
You might not have that, but it's something to if it's a large sum of money. I think
Is
so.
there a number, like a financial number?
I don't think there's any specific metric to apply. I guess you put it this way: a crime is technically a crime,
Probably it depends.
but it does depend. Yeah, are they going to care?
Yeah.
That's the question, I think, or do they have the manpower or the resources to execute on that? So
Yeah, if it's in the tune of millions of dollars, it might
okay,
catch their
that might
eyes.
exactly. But if it's like again organic chlorine, maybe they don't care,
Yeah.
right? They probably don't. I'm going to go with they probably don't. So At that point, though, the association has to make a business decision. Now, realize that decision is often derived upon the economics of it. So, Billy the embezzler stole $100.
What happened to Vinny?
That was the
Oh,
vendor.
that was the vendor.
That was
Okay.
the vendor.
That was Billy's cousin.
Okay,
Yeah,
gotcha.
no. Billy's the individual on the board who's embezzling, and he stole $50. Are they going to file suit over that? Probably not. Maybe there's some internal something that they can do there to get him off the board, but they're probably not going to prosecute. So really, it's a business decision on the board at that point
Okay.
to see what they want to do.
Interesting.
Now, here's where it gets interesting, I suppose. I'm kind of thinking about this out loud. Let's say it is $1 million, and the board decides not to do anything against this individual. And they go back to the owner and say, hey, you were right. They stole $1 million. And the owner says, well, what are you going to do about it? Nothing. At that point, the owner might actually have a cause of action against the association.
Because it was their fiduciary duty.
That might become a breach of fiduciary. That might become negligence. I mean, that becomes its own cause of action at that point.
Interesting.
Well, what if they execute some sort of so let's just say that they just kick them off the board, but no funds were paid back.
Well, the question is, did they take any action against that individual other than kicking them off the board? Now, if the association lost $1 million, that's actual harm to the association, and they didn't go after that, I mean, that could be a huge problem for the board. That they didn't seek any sort of disgorgement. Because we're dealing with a lot of money.
Have you ever seen that happen?
I've seen situations where the board has covered tracks of a board member and has decided not to do anything about the problem, and we've gone against an association for that, yes.
Okay.
So yeah, it does happen. And sometimes what it is, they're circling the wagon, and because maybe other people are involved, and that becomes its own different beast unto itself.
I got a curveball for you. You ready?
Oh, no.
Okay.
You know how if a homeowner, an association can basically put a lien on a property or even sell the property if they have unpaid dues.
Okay.
Let's just say in the situation they steal $1 million and they don't repay it. Could they take their house in that situation?
Yeah, typically how that would work is a lawsuit would be filed.
Sure.
They would prosecute it to judgment. Once they got a judgment, then they could put a lien on the property. And if they don't pay back that $1 million, there could be there's two ways to foreclose. It's a non-judicial foreclosure or a judicial foreclosure. Typically, it'll be non-judicial. It's just an easier process, which is a series of notices. And after the notice period is up, it goes to trustee sale. So that could be a way of getting the money back, assuming there's equity in the property.
Interesting.
But you can also, you can levy bank accounts once you have a judgment.
Sure.
You can do this fun thing called a judgment debtor examination, which if you have a judgment against somebody, you can go to the court, and the court will essentially compel them to show up at the courthouse, and you can sit down with them face to face, asking them about their financials. Now, if they don't show up, the court will issue a bench warrant typically. They'll give them 2 bites of the apple, though. So if you show up and this judgment debtor was supposed to show up, they don't show up, you go in front of the judge, say, hey, they didn't show up, can you issue a bench warrant? Typically what they'll do is we'll issue it, but we're going to hold it. We're going to give them one more chance to show up. If they don't show up a second time, typically a bench warrant is issued. But that's a great way to get into the financials. It's pretty aggressive, though. Listen, if they show up with cash, you can actually say, can you take out your wallet? How much cash do you have?
Wow.
Let's say that they have $1,000. You can then go after the judgment debtor examination happens. You can go back to the bench and do what's called a turnover order and request that judgment debtor turn over the $1,000 to help satisfy that judgment.
Or their watch or something else.
Yeah, if they're wearing a Rolex, if they're that insane, yeah.
The keys say BMW on it.
Yeah.
No, you
Hand
can,
it over.
yeah.
You show up in your bike and your tattered clothes.
100%. I'm not wearing anything in court.
There's certain limitations. There's certain protections built in, but we're not a collection firm.
Sure.
But we've been in a situation where we've advocated in this sense. We've had people turn over cars before. We had one situation where we had a turnover order. We secured 2 cars, and we said, okay, please deliver them to our office, and we turned them over to our client. The judgment debtor, though, turns over the cars, but then siphons out the gas. I didn't see that coming.
Can't make this stuff up.
So there was no gas in the vehicles.
Oh, that's hilarious.
They actually pulled it out.
I thought for sure you were going to say the radio was gone.
No, because that would, I think gas, it's kind of, it sort of got away with that.
Yeah.
But yeah, no, you see crazy things. Jewelry has been turned over. It's a very powerful tool.
What would you recommend for this to be avoided in the first place? What would you recommend as an attorney? I guess this goes more maybe towards the other side of you represent homeowners, but maybe on the other side too, to try to keep this from happening in the first place.
Well, I don't know, because you sometimes don't see people's fangs ever, right? I mean, you could think this person is wonderful, and typically the self-dealers, the embezzlers, they're the nicest people on the planet.
Yeah.
They're con men and women. So they're really good at what they do. They have an avatar personality where you don't know who you're dealing with.
Sure.
So unless you're
Who the real Vinny or the real, what's his name?
it's hard to say.
Billy, sorry.
You know, I think it just goes to the election process. Know who you're voting in. Try to do some research on them. But sometimes you'll never know.
Yeah.
Sometimes I think it's impossible to say.
I would assume transparency is just key in most aspects. If there's one thing we've learned in all of this,
Well,
it's
Maybe
transparency.
you need Colby assessments before you go on a board.
Colby's, I don't think, is going to teach you whether or not someone's going to steal money, though.
And it's a volunteer.
And you can't
This is
ask
true.
them. You can't say, hey, you're a great candidate, but are you going to take money from the
On a
community?
scale of 1 to 10, how likely are you?
Yeah. I am very, very. I'm definitely a threat. I'm like
When you go on a
10.
jury and they're like, do you know an attorney?
Right. So I don't know if there's anything you can do other than know the candidates, know them as well as you can, and cross your fingers. Because it does come up. I mean, it's not a major thing that we see all the time. We see it. We absolutely see it over the last decade or so. But it's not so common where it's like, negligence, failure to maintain, selective enforcement, harassment. I mean, those are much more common themes.
Yeah.
The self-dealing, the embezzlement, it comes up, but not with the frequency of the other causes of action.
Okay.
All right, you ready for the Reddit?
All right,
Okay.
let's do this.
All right.
Am I reading this or are you, Marty?
No, I'll stutter through that and where it'll sound like
This
a
is where
machine
my
gun.
pre-teacher
Yeah.
knowledge comes in. Okay.
These are always weird too because I never know where they're coming from.
We're just gonna assume that they're in California.
I'll assume California.
Yeah,
Reddit has such fascinating people.
they do. Oh my gosh, it's wonderful.
All right, here we go. Hello, I'm turning to this platform for guidance because my neighbors and I are facing a significant issue. 5 years ago, I moved into my Arizona community, and initially, our Homeowners Association was satisfactory. However, 2 years ago, the HOA board made a regrettable decision to switch management companies, leading to poor landscaping, water leaks, and a generally unkept community. In response, many of us began attending meetings and offering help. We discovered a conflict of interest. A board member, let's call her Lisa, is also an employee of the management company and consistently approves their expenses, despite needing a majority of 3 out of 5 votes. This arrangement seemed questionable, especially as our community's conditions deteriorated, looking neglected for over 9 months while fees were still collected. Frustrated homeowners living in properties valued around $600,000 demanded change. Typically, our HOA votes by mail, but due to suspicions of fraud and to ensure transparency, it was recommended that voting occur in person. This led to the election of 2 new board members and the ousting of Lisa and another member. However, when the new board proposed changes, including switching management companies, the current management contested the election's legitimacy, claiming undue influence because of the in-person voting. They continued to operate with the previous board members, ignoring the new board's decisions. Legal intervention became necessary as the management company refused to relinquish control, leading to a deadlock where they continued collecting fees without acknowledging the new board's authority. Additionally, the management company increased their fee 5-fold without raising our dues, essentially profiting exorbitantly. A petition for their removal is underway, though Lisa actively sabotages this effort by removing the petition from the communal area. The entanglement deepens as the old management holds onto the community's funds, preventing the new board from making any significant changes. Some homeowners, including myself, ceased fee payments, which led to threats of liens and additional charges. We've engaged a lawyer to navigate this complex situation, but I'm seeking advice and insights from anyone who might have experienced something similar. This ordeal has become incredibly stressful to the point where selling my home seems like the only escape. Thank you for reading through my predicament.
Oh my God, what a dumpster fire.
Most of these on Reddit are dumpster fires.
Yeah. So I don't know the laws in Arizona, let's frame it out in California. Yeah. I think that'll be helpful. So initially, what you're seeing is on the one hand, you're going to have breach of contract, breach of fiduciary for failure to maintain the common area. That's sort of your garden variety causes of action. even though it's the hands of a management company, again, under agency theory, it imputes back to the association. So let's start there. That's sort of the easy, low-hanging fruit stuff. The self-dealing component is interesting in the sense that you have a board member who is driving, it sounds like, the relationship with a management company, a very bad management company, because he's also employed there. So I don't know if there's a actual economic benefit or if it's just like, hey, you're an awesome employee, good job, keep driving work to us.
Yeah, unless she's getting a commission. There's
Possibly.
a rainmaker over there or something.
Possibly. So there's an issue there. There's a conflict issue there, right? In terms of sort of independent economic benefit, that's unclear. It could just be like, you get to keep your job because you landed this big client and we're, raking them over the coals. And we like that. We want to keep doing that. Where it gets very weird for me, though, is the control that the management company has over the association, right? Because you have to remember, the management company is a vendor. That's all they are. It's a contractual relationship. So as to how they have control over the governance of the community, I don't know how on earth they would have gotten that.
It must be a corrupt board, or the board's in cahoots.
It sounds like something's way off on this fact pattern, because if you're an association, you're a board, and the management company is like, well, we're not going to relinquish control. We're going to, hold your bank accounts. You just terminate, and then you go after them for a breach of contract. Say you're stealing money from the community. You're illegally withholding our bank accounts, which are our bank accounts. You can't do that. Even though we had maybe contractual provisions that allowed you access, we're terminating that access. The association has the power there as to how this management company hijacked the association. I can only imagine that was done because there was some sort of internal permission of that.
Interesting.
Like, the association is allowing this to happen. But in California, I mean, what an association would likely do there is file a lawsuit against the management company. I mean, there might have to be some sort of injunction or court intervention to untangle some of this, but you'd be looking there for disgorgement. I mean, if the management company continues to profit off the community without authorization or permission and is just, let's say, pocketing those fines, well, the association would be looking to disgorge that from them. And you might even be in fraud land, misrepresentation.
They should have an attorney as well. That's the HOA should have their own attorney. That would be
typically they do. Maybe, I mean, unless it's a very, very small community, and it's just kind of internally just sort of a mess.
Yeah, we probably need more.
And it might be one of those where it's so loosey goosey that a management company just came in and just exerted control and is just dominating the association, right? I think if you got the right attorney and legal team in there, they can untangle this pretty quickly. But that presupposes that the association or the board members actually want that to happen.
Well, we do know one board member for sure is in cahoots with
Correct.
so it's likely that she just wrangles the other board members to vote the same way she does.
Correct. So you almost have two things in this scenario. You have an association as entity. Again, it's the entity which would likely have action or causes of action against the management company, but then the owners would likely be able to come in on different fronts on this as well. They would have individual standing given what is happening with the community. So that's a great fact pattern, though.
Yeah.
There's more to that story. I mean, that's
for sure
massive, but that's interesting.
That'd be
it's unfortunate.
That wraps the
All right, are
personalities.
we done with personalities?
We are done with personalities.
All right. Let's see what. Oh, we're starting a new series too.
Yeah, new series. The infractions or case types.
Yeah. So, now that we've gone over bad HOA board members, right?
Personalities.
Personality types. What do we see? What I think is very relevant is now that you've identified the players and you have a better idea of why these things happen, some of the motivation, I think it's now important to identify, okay, from a legal perspective, how do you articulate it in a cause of action perspective? And so next series, we're going to be going over the different causes of action. And, just to tease it, as you like to say, there you're looking at breach of fiduciary. What does that look like? What does that mean? Breach of contract. Negligence, just common law negligence. What is the standard of care? How does it materialize? And by knowing this, I think an owner is in a much better position to start labeling these things, because we speak with a lot of owners and they have a lot of bad around them, right? It's like, our common area is falling apart. The pool doesn't work. The roof is leaking. that's one way to describe it. That's a factual articulation of what is happening. But to elevate that vocabulary, it's a leaking roof, but ultimately it's negligence, or it's a breach of the CC&Rs because the association has an obligation to repair and maintain the common area elements. So really in the next series is really stepping up the vocabulary of an owner who's been impacted by a bad HOA.
Okay.
So
Exciting. Let's do
that'll be
this.
fun. So hope you guys enjoyed the series, and we look forward to seeing you guys next time.